Our next case for the morning is Pascoe, if I'm saying it right, where it's Clearview Local School District Board of Education. Please come forward. And before we get started, is everyone present we're expecting here today, and are we ready to proceed?
Yes, Fred.
Very good. You know each party will have 15 minutes to present their argument. The appellant may reserve up to 5 minutes. Counsel, how long would you like to reserve?
I would like to reserve 3 minutes.
3 minutes, very good. I will be keeping time up here. There's no way for you to see it, so I will let you know when you have about a minute left in your initial time. I can try to give you a warning at that point. I will not give you any warning at the end of that short 3-minute period, and I'll try to let you know about a minute, and your 15 minutes is up as well, Counsel. The arguments are being recorded, so when you come to the podium, first please introduce yourself for the record. Please stay behind the podium if you would, so that A, we can hear you, and we're video recording, and if you move too much, we'll lose you at that point in time. I don't know that it matters in this case. If you would have anywhere applied, if you would have any minors or victims or anyone of that nature, please refer them by initials, or some kind of like child or victim or some other term. Again, I don't think it really applies in this matter. Having said that, the judges are ready to brief and are ready to proceed whenever you are.
Thank you very much, Your Honor. May it please the court, I'm Florence Murray from Murray & Murray. I represent the plaintiff, Kristen Pascoe, in this matter. Kristen Pascoe was a family consumer science teacher for the district, for Clearview Local School District. The issues before this court are whether there's a genuine issue of material fact that she was qualified for a teaching job with or without reasonable accommodations, and whether she suffered an adverse employment action that would prevent summary judgment on this disability part of the claim. The standard of review, as you know, is de novo, which allows you to both review how the trial court reviewed it, came to its decision, as well as the underlying facts that were reached in order to reach that position, except that you're allowed to have a different focus from the trial court. This is not just a failure to make a reasonable accommodation case, but when the district failed to allow for the reasonable accommodations, or provide for them, or to provide alternatives, it in fact was engaging in an adverse employment action.
Well, counsel, this is a little confusing for me, so I was hoping that you would argue so I could ask for some explanation or something to help me. So the claim is in the complaint that nobody's really contesting that she fit the requirements of ABA.
Correct.
Okay. So the first part of the complaint is that they didn't reasonably accommodate her in regard to her disability.
Correct.
And the trial court said there was a genuine issue of fact on that.
Correct.
Okay. So the only issue we have in front of us now is the second issue. I'm referring to the second issue, but it's even confusing
Yes.
with that. Because if you don't accommodate somebody, isn't that discrimination to begin with?
Well, yes, Your Honor.
Yeah. So when the trial court says there's no discrimination here, as part of the second part, and that's what you're appealing, how does that relate to the accommodation then?
So that's a very good question, and thank you very much for that. They made one of the arguments that appellee takes exception to is this direct evidence of an adverse employment action, and so we've never not said that this is direct evidence, and whether or not the court reaches that through cases such as Caldwell, or whether it goes through the indirect the inference. We result in the same outcome, which is that in April of 2014, when the district meets with the appellant to determine whether or not she has reasonable accommodations that they can make, and it is a one-way process. And as the superintendent says, even after the August meeting in 2014, it's a take it or leave it. We give you what we're going to give you, and you can take it or you can walk away. But as a result, by making that in their case, a bright line decision that no, we're not going to accommodate any of these things, and we're not going to offer you anything to try and remedy them, the district was necessarily engaging in discrimination. And that's consistent with both the Talley case as well as some of the other cases that we've cited in our brief, including the Dalgen Court case as well.
Well, that's what I'm getting at. So how does the trial court say no discrimination, but there's an issue of fact about reasonable accommodation?
I don't really know that, Your Honor.
Because it seems kind of contradictory, because it seems like the trial court should have said, well, there is a issue of fact as to discrimination via a reasonable accommodation, but the fact that she retired and, and they're claiming that she, voluntarily left and all these kind of things, and they did discriminate against her in regard to all that, is a completely different issue.
But related issues, of course, because by failing to offer the accommodations, Kristen was successfully teaching in the years prior. They had done the things that she had asked for that they denied that they would do for the upcoming year, which was to put her classes in blocks and only have her teach 2 types of classes each semester. So those were things that she was asking for to be maintained, because she knew that if some things were in place, she'd be able to keep doing the job she was doing. She asked for also some additional things, which they denied, which included an additional planning period. When she gets to that point of the fall, and she, not only do they not grant the reasonable accommodations, but they, on top of that, increase her course load by 50% by having her teach 3 classes instead of 2. They decrease her budget by 50%. So now that one accommodation was illusory because they said that she'd be able to use it to get delivery of groceries in order to assist her in her disability, and instead take away money and say, but you still got to do it with the same budget you have. And
Counsel, I guess maybe, because we have such limited time, so I guess I want to really zero in on what is your discrimination claim, I can't even talk, that is not based on reasonable accommodation.
Well, really, the resignation would be the only thing that you could say.
So
one
that's what
could
I'm saying,
argue.
so you're saying the school district, how did they discriminate against her in the resignation, that's what I'm trying to say, because she had the right to resign, obviously.
Well, so she was forced into, so the district wants to, they want to punish her for taking on the semester in spite of the additional challenges they put in front of her. Kristen did the best she could to plow forward in spite of those additional hurdles they placed. She then is forced out on disability leave because she can't do it by come November of that school year. So she as a public employee has a right to apply for disability benefits. Disability benefits are, one of the purposes of it is to help get you back to a position where you can work. And so the district then arbitrarily decides that she's resigned from the position at that point, when in fact, under even the policy itself, there's 2 things. Under the policy itself, she had the right to come back to the job within 5 years. But also, under case law, including Coomer, she was not being, when she made the disability application, it was simply about her disability and whether or not she could work with those disabilities. Those disabilities were multiplied because of what happened during the school year, but she was willing and able and testified she wanted to go back to work. And she had that right to go back to work because STRS was not making a determination that related to reasonable accommodations. It's simply as to the disability itself. And so when they made the determination she resigned, they were taking what STRS did in its application process and using it against her when those disabilities were increased, impacted by, her fibromyalgia was multiplied by the additional hurdles they put in her way this fall of 2014. Did that answer your question?
I think so, and I'll ask the same question to the other side too, so I'll have to.
Okay, thank you very much. So I referred to the fact that they had cut her budget, but the other thing they did was they refused to allow her to transfer to another position when she made that application, as a way that she thought she'd be able to continue to do the work, but in a different position. They didn't even consider her for that. And then they didn't group the courses. So one of the things she asked for was to have courses grouped so that they'd be in blocks, so that she'd have less to take down and break down and set back up. So in the case of a baking course, you have to get out all the cookware, and you have to get out the materials and the supplies, and then the students make things, and then those things are there, and then they have to be put aside so that you can do the next course. Well, if you're teaching baking and then baking, they're similar, right? You're going to use the same materials, and so you don't have to break it down every period. And so that was one of the things she asked for, but in fact, when the semester came, those classes were not, they were not grouped, they were staggered. And the district didn't promise that they would give that to her. That was one of the reasonable accommodations she asked for. And that was one of the things that they not only said they wouldn't grant, but they made it more difficult in the way that they showed the classes. And one of the things that Kristen testified to was right before the school year started, they actually showed her how her schedule was going to be, and then it was different when she started the school year. And that included not only the grouping, but the way the classes were laid out in the course of the day, as well as the types of classes she was going to teach. The district says that under the contract, they couldn't give her an extra planning period, but the case law says that obviously the ADA comes before any contract. You can't contract people out of their rights under the ADA. So that's one of the issues. That's a factual issue that should be sent to a jury for them to review. So our argument is that we have proven there's a genuine issue of material facts on each of the parts of the prima facie case that the plaintiff must prove. That she, and it's not disputed that she had a disability, that we say that she was otherwise qualified for this position because, as evidenced by the years before, she had excellent reviews doing the same job, and she'd had these symptoms ongoing for several years until she
About a minute left in your initial time.
Thank you. Until she received the diagnosis. And then with reasonable accommodations, her doctor said she'd be able to do that position, and there's no reason to believe that she wouldn't be able to because she did so in the years prior. And so the last position on this is whether or not you go with the line of cases that have clarified what was done by the Supreme Court, and those line of cases would include Caldwell, which provides for, that was one where the teacher had needed a scooter to get around, and what it says, and this is one of the last points I want to end with, is that an employee may not assert a claim for constructive discharge every time an employer fails to accommodate her disability when an employee makes a repeated request for an accommodation, and that request is both denied and no other reasonable alternative is offered. A jury may conclude that the employee's resignation was both intended and foreseeable, which is what we argue their adverse actions did in this case. Thank you very much.
Thank you. You'll have the remaining time for rebuttal.
I'm going to start you out. I'm sorry, but
Please.
isn't this really just one big cause of action? In other words, this teacher claimed that she was disabled, which nobody seems to contest, okay? And she asked for accommodation. The school district gave her some accommodation, but didn't give her everything she wanted. She's saying that wasn't reasonable, and if they had given me reasonable accommodations, I'd still be working there, because since they didn't give me reasonable accommodations, that exacerbated my fibromyalgia and necessitated me quitting, which was foreseeable. So how's that two causes of action? I'm trying to figure out how the judge did this.
And if you would, please don't forget to introduce yourself.
Thank you, and I appreciate the question right up front because this is where I wanted to start too. I'm Elizabeth Braverman. I am counsel for Appellee's Clearview Local School District Board of Education. And Judge Gar, it's a great question. The answer to your question is that courts both in Ohio and in federal courts have set forth separate standards of proof for claims that are constructive discharge claims, which are adverse action claims, versus claims that are failure to accommodate claims. And so what the appellant is attempting to do in her brief, as I read it, is conflate those claims, and that's incorrect. The trial court recognized and correctly articulated that these are two separate claims with two separate standards of proof. The constructive discharge claim, courts have held that a constructive discharge claim, which is a claim that a plaintiff or an employee resigned but was actually forced to do so by her employee due to some sort of bad adverse action, a constructive discharge claim can be based on an employee's alleged denial of reasonable accommodations, but these courts have placed guardrails around those claims. So a partial denial of accommodations, which is what plaintiff or the appellant is alleging happened here, cannot constitute an adverse action for the purpose of constructive discharge. Rather, courts like Talley out of the Sixth Circuit and the Caldwell case that my opposing counsel just referenced clearly state that in order for a constructive discharge claim to be based on a denial of accommodations, that denial of accommodations essentially needs to be total. The employee needs to have made a repeated request for accommodations, which the employer needs to have denied and offer no alternative accommodation. That is simply not what happened here. In this case, the employee requested 10 accommodations beginning in March of 2014. After she made that request, she met with her employer on 3 separate occasions with the benefit of union representatives and had in-depth, extensive conversations about why she needed those accommodations, how the employer would provide them, what alternatives there were. Ultimately, the employer chose to give her 8 of the 10 accommodations. It only denied 2, which it did not believe were reasonable. I won't get into all of our arguments.
And the whole point is, yes, the trial court did say there's an issue of fact with that.
Correct.
Yeah, so that's why I guess I'm a little confused too with everybody today, because it seems like we're talking about the accommodations.
Right.
And I'm like, the issue before us is what? And you're saying the issue before us is constructive discharge.
Correct. Correct.
So, and you're saying the case law provides that there are 2 distinct causes of action with that.
Correct.
That there may be remedies or damages as a result of the reasonable accommodation, but you're going to have to show separate proof in regard to an actual discharge.
That's exactly right. And if you look at the Caldwell case, the 11th District case, that case has a really nice explanation of the separate standards of proof for those 2 different causes of action, and then applies the different standard of proof. Like in this case, that plaintiff brought a failure to accommodate claim and a constructive discharge claim, and the court correctly, in that case, separately analyzed both of those cases.
And here's the reason, I'm not completely crazy just out there on that limb. The reason why I'm asking these questions is because I couldn't figure out how we could look at this appeal yet. Okay?
I'm sorry.
I couldn't figure out how we could look at this appeal yet, because it seems like, the trial court, said, well, these are distinct, but yet they're all the same thing. And in other words, you should be able to immediately appeal because, for judicial, resources and, blah, blah, blah. But here's the thing, I guess what I'm trying to figure out is, all that stuff about accommodation is gonna come in even if we reversed on the wrongful discharge. So you're still trying the whole thing at the same time.
Let me answer. I think there's 2 parts of my answer to your question. The first part, I do want to point out that although we did not oppose appellant's motion to certify this claim for appeal, we did not join in that appeal. And And so that's not my argument to make of why this case. However, what the trial court held in its 54B order was that these are two, as you say, these are two separate claims. They rely on separate legal justifications. And I do think that's correct for the reasons that I just explained to you. The holding in the case that we are bound to on this appeal is what the trial court held on reasonable accommodations, which is that Clearview granted 8 and denied 2 because it did not believe that they were reasonable. And so those are the facts.
And that's an issue of fact.
Correct. And so that's, I think at this point, for the purposes of this appeal, that's an undisputed fact. And based on that undisputed fact, our legal argument is that the constructive discharge claim and then also the other adverse action employment claims should be, the trial court summary judgment order on those claims should be affirmed.
So basically what you're saying here this morning is, I know you made an argument about this in your brief, and that is, we're really just talking about limited, even if she got an award, it would be limited damages in the school board's mind, because you're not going to be able to get the damages for the constructive discharge just for the reasonable accommodation, which would have only been 3 months maybe?
That's correct. As it stands, if we had gone to trial on the case as it stands, based on the trial court's existing order, she would not be entitled to back pay damages because she wasn't constructively discharged.
Or front pay.
I'm sorry?
Or front pay.
Correct. I did also want to note a couple of procedural pieces. We've talked about the standing in terms of the trial court's order on reasonable accommodations, whether that is subject to that appeal, and it is not subject to this appeal, that factual and legal issue. I do also want to note that in the appellant's brief, there are several arguments that were raised to this court for the first time that were not raised below. First is that the prior partial denial of accommodations to the employee constitutes direct evidence of discrimination both for the purposes of constructive discharge and adverse action. The second argument is that the timing of the qualification inquiry for the purposes of the constructive discharge claim, that should happen at the time she requested accommodations, not at the time she actually resigned. That second argument, the appellants actually argued the opposite in their briefs to the trial court on the motion for summary judgment. But in either case, the Ohio Supreme Court has held on multiple occasions that parties cannot raise arguments for the first time on appeal, and they certainly can't take advantage of errors that they either induced or argued the other side of to the court. So we would ask the court not to consider those two arguments. As I already have kind of walked through, we also believe that both of those two arguments are incorrect. So we've talked already about the standard of proof for the constructive discharge claim. I wanted to dig in with my remaining time to the qualification argument as well. The appellant is arguing that the timing of that qualification argument, we should determine whether she was qualified for her job for the purposes of her constructive discharge claim in March of 2014 when she requested accommodations, not in November and December of 2014 when she applied for disability retirement and resigned her employment. And that is simply wrong. Constructive discharge, the adverse action, the constructive employment decision in a constructive discharge claim is the resignation of the employee, the constructive discharge. And that's the point then that we need to consider whether the employee is qualified for her job or is not. Of course, that holding, that legal reality reflects actual reality. If a plaintiff or an employee, resigns her employment because she can't do it anymore, that's not a discharge, that's not a constructive discharge. It's simply an employee resigning her employment because she can no longer fulfill the essential functions of her job.
So again, you're looking at it as very two definitive time periods. One is whenever she asks for accommodation, that you would look at whether she's able to perform the job with reasonable accommodation. And then whenever she's asking for a constructive discharge, you can look at the time period. Was she, when she resigned,
those are two separate claims that require two separate standards of proof. Yeah. And here in this case, as the trial court held, there is no dispute of material fact that she in fact was not entitled or qualified to fulfill the essential functions of her job at the time she resigned. The plaintiff made an uncontested, a detailed and voluntary statement to SDRS at the time that she requested disability retirement, explaining all of the various ways in which she was no longer qualified to be a teacher. And cases are very clear, including the Cleveland case out of the U.S. Supreme Court, that employers are entitled to rely on those types of statements by employees when they seek disability retirement, that the employee is representing and her doctor are representing that she is no longer able to fulfill the essential functions of her job. Now, of course, the employee is entitled to come back after she makes a statement like that and explain to the employer with justification and evidence why that's not the case, why even though she told SDRS or the Disability Retirement Board that she was not able to fulfill the essential functions of her job, that she in fact could have done so with reasonable accommodations. But the plaintiff simply has not done that here. We have 0 statements after her SDRS disability retirement of why she may, notwithstanding that statement, be qualified to continue to fulfill the essential functions of her job. I would also note factually that today, 10 years after she retired, she continues to accept SDRS disability retirement benefits, which means she is, by Ohio law, prohibited from teaching or being paid as a teacher. We just simply do not have any kind of doctor statement or even a statement by the employee with actual justification of why she would be able to fulfill the essential functions of her job.
And none of that has come out in discovery?
No, plaintiff has produced no evidence that she would be able to do that. Her brief does point to one statement in her deposition that said that at the time she submitted her STRS disability retirement statement, she thought maybe she might be able to come back to work at some time in the future, but that's the extent of the statement. There's no justification, there's no explanation of what those conditions would be, if that would require an accommodation by the employer. We just have no knowledge about that. And then one last point about the qualification piece before I move on with the remainder of my time.
You're down to about a minute left.
A minute left. Okay, well then this will be my last point. The conditions on which she requested disability retirement benefits are different than the conditions that conditioned fibromyalgia, which she had previously disclosed to her employer. The conditions for which she sought disability are ADHD, depression, and several others, none of which she had previously disclosed to her employer or requested accommodations for.
And I know you're almost out of time, but that gets into her argument that her condition was exacerbated, and that's when she developed migraines, that's when she developed anxiety, that's when she had all these issues that she didn't have at first. So you're saying that you're not allowed to consider that exacerbation, or that her condition got worse, obviously, because that's a separate cause of action, and that wouldn't be part of what she would have to prove.
Correct.
And your time is up. Please, number one, take your time and answer the question. And when you're finished, then please briefly continue.
Thank you. Yes, that's right. There are two separate causes of action. With regard to the, if in fact her condition had been made worse, allegedly because of the failure to accommodate, then what she could have done is what is contemplated by the cases, which is to ask for additional accommodations or tell her employer that the accommodations that the employer was providing for her and that they had agreed on weren't working for her. She never did that. After the accommodations were provided, she never once said to her employer, this isn't working, I need more, I need this other thing. Nothing like that ever happened. So I appreciate your questions. If I will conclude, we respectfully request that this court affirm the trial court's May 2023 summary judgment order. Thank you.
Thank you. So to address the issue, well, standing aside from the issues that council raises that we did not raise in the lower court, Clearview's decision to treat Kristen as resigned is an adverse employment action. And it is tied to Kristen's disability, and it is also one of the factors that establishes that we've met the prima facie elements of the case.
But how are we supposed to review things that were not raised in trial court below?
The decision to treat her as resigned as an adverse employment action.
Well, you started your argument
Yeah.
with the things that you had not raised in the.
I said setting aside.
I'm sorry.
That's-
I apologize.
it's
My
okay.
hearing is not what it used to be. Okay.
I'll try and stand closer to the mic. And the courts have said, in Hofstadter in 2018, the Sixth Circuit said, this issue of whether or not they're otherwise qualified to perform their essential job functions with reasonable accommodations is highly fact-specific. And again, that's something that should go to the jury as opposed to being raised, as opposed to being ruled upon by this court in the summary judgment, because the court did not consider all the facts in the with the light favorable of the plaintiff, the person who was not bringing the motion for summary judgment. And that's one of the issues that we take exception to. But the Clark case is especially instructive on this issue of this failure of an employer to reasonably accommodate an employee's known disability can constitute an adverse employment action under both federal and Ohio law. And that is the Clark versus Whirlpool, which is 109, the federal appeals of 750. It's a Sixth Circuit case out in 2004. And it says specifically in it, of course, when a request would be futile, we've excused the failure to make it when the need for an accommodation was obvious to the employer. The ADA doesn't require a person to perform a useless act. And that's important as to this issue that counsel raises, which is that she didn't come back to them to say, okay, we've done this, we've gone through this iteration now a couple times, and I can't do it. They denied it, and they said, again, the superintendent said, this is it, you take it or leave it, but it is what it is. And so there was it was made very clear to Kristen, there was not going to be any more iterative process on this issue. And so it was futile for her to bring it up at that point, and so she could have resigned at the start of the school year to say she couldn't do it with reasonable accommodations. But the issue here is that she did try to do it. She did want to teach, and she did everything she could to keep teaching. And so when she...
I think your time is up. You may briefly conclude.
Thank you. So when she resigns, that is something that was necessitated by the actions of the school district in discriminating based on her disability. Thank you.
Thank you, and thank both of you for your presentation this morning on behalf of the court. The court will take the matter under advisement and issue a decision in due course. When that decision is reached, it will be mailed to you by the clerk of court and also available on the Ohio Supreme Court's website.